This webinar will discuss the new sexual harassment law. Due to the sensitive nature of the topic, we advise viewers who may be or have been affected by sexual harassment to exercise caution and consider their well-being before continuing. Welcome to today's webinar, and thank you so much for joining us. I'm Simon Fowler, CEO of Empowering People Group, and I'm delighted to be hosting this session this morning. Before we get started, here's a quick overview of who we are and why we're here today. EPG consists of 4 innovative tech-led companies that are on a mission to simplify employee experiences and empower people to drive business success. Today, our mission is to try and simplify the complexity of a new piece of legislation coming into force on the 26th of October, so not very long from now, which is all about the reasonable steps organizations need to be taking to prevent sexual harassment at work. A quick bit of housekeeping before we get into the session and a little more about what you can see in front of you. This will be a repeat for some of you who have been with us before, but the screen is customizable, so you can drag and move the speaker and slide views to position them how you prefer. You'll also find speaker bios listed in the panel next to these. We've also included some resources on the topics being discussed, which you can download during the session and which we'll send out to you after the webinar. Lastly, but definitely not least, you can see a contact us button, so you can get in touch with us at any time. If you'd like to ask a question, there's a Q&A comment box at the bottom of the screen. We'll try and answer as many questions as we can towards the end of the session, but if we don't get to them all, we'll follow up with answers after the session. I'm delighted to be joined today by Halborns Head of Legal, Jess Kelleher, to share her employment law expertise and the view from the tribunal in terms of what this new legislation will really mean for organisations moving forward. Jess, do you want to say hi?
Hi everyone, delighted to be here and chatting with you all today.
Brilliant, thanks Jess. Also on the panel today is Hayley Saunders, an HR technical consultant at AdviserPlus. Hayley brings to the table massive experience in supporting customers to embed best practice people strategies that empower and transform employee experiences. Hayley, do you want to say hi?
Hi, yeah, good morning everyone. Great to be here.
Great stuff. So what are we covering today? It's an unfortunate reality that sexual harassment is an issue that's never too far away from the headlines. We've seen major names such as CBI, McDonald's and Lidl all facing allegations of toxic work environments rife with sexual harassment and inappropriate behavior. But on top of that, stats would suggest that what's reported is just the tip of the iceberg. We know that around 30% of employees have experienced at least one instance of sexual harassment at work in the last 12 months. Add to that, almost half of all sexual harassment goes unreported, and it's really easy to see why the legislation we're discussing today is being introduced. Now, the legislation doesn't take effect until the 26th of October, but it's definitely our view that taking proactive steps early is not only great from a cultural point of view, but also help you put your best foot forward when the act does kick in. Which is why we're here today with our usual solutions-focused, proactive approach, and always with the aim of simplifying ER. We're here to help you prepare early for the impact of the changes and the practical steps you could be taking. As we mentioned, as a thank you for joining us, we'll also be providing a checklist to all attendees that you're able to work through in your own time, along with a board summary document, which you can share internally to cascade the information from today's session to your key stakeholders so they're clear on what this change means in practice. We'll share more on how to access these at the end of the session. So, between the three of us, we're going to give you a clear and concise summary of the need-to-know detail and the practical impact of the changes so that you're all set for the 26th of October. There's a lot for us to get through, so let's get cracking. So Jess, it makes sense to kick off with you. Can you give us the headlines of what the current position is in regards to the current definition of sexual harassment, and then what exactly the new legislation is going to change?
Absolutely, Simon. So the catchily named Worker Protection Amendment of Equality Act 2010 Act 2023 will make a significant change to the current law on employers' obligations to protect their employees from sexual harassment, i.e. unwanted conduct of a sexual nature which violates their dignity or creates an environment that is intimidating, hostile, degrading, humiliating, or offensive to them. Now, currently, employers are liable for their own acts of harassment and their employees, unless they can show they took all reasonable steps to prevent harassment or discrimination. Harassment is judged from the employee's perspective, so they will be protected provided their reaction is reasonable in all the circumstances. These aspects of the law aren't changing. However, from the 26th of October this year, employers will be required to demonstrate that they are complying with the new duty to proactively prevent sexual harassment in their workplaces by taking reasonable steps to prevent it. Failure to do so will bring the possibility of some new potentially significant financial consequences.
Thanks, Jess. So what does that mean in practice? Can you give us some actual examples of what sexual harassment might include?
Certainly. So examples of sexual harassment could include, but aren't limited to, unwelcome sexual advances, touching, sexual assault, sexual jokes, and displaying pornographic drawings, or sending emails with material of sexual nature. An example from a recent case involved a manager texting and emailing a trainee, repeatedly asking her to remove her jumper and encroaching on her personally. So in this modern age of hybrid working, sexual harassment can take place regardless of whether you're working remotely, in that case via text and email.
I think that's a really important point to highlight. So, to ensure all members of a workforce understand that communications via digital channels that are not work-related aren't excluded from a workplace harassment claim.
Yeah, absolutely. So just to conclude on the details of the new duty, although it has been a slightly watered down proposal from the original proposal, which required employers to show they had taken all reasonable steps, and previously also included employers being liable for harassment from third parties such as clients or customers, the consequences that arise from breaching the new duty mean it's worth taking proactive steps now so that you're ready and compliant for October.
Yes, and as I said earlier, Jess, October doesn't seem very far away. So you mentioned there are some new financial consequences and significant ones at that coming with this new legislation. Can you tell us what that's likely to look like?
That's a great question, especially because we've already seen tribunal cases published in the past 12 months where significant compensation awards have been made for sexual harassment claims. So understanding the additional consequences the new duty will have is really important. So starting with the financial consequence, although the new duty is not its own standalone claim, it will increase what tribunal awards look like for sexual harassment cases, because if an employee successfully brings a harassment claim, the tribunal would then consider if an employer breached the duty. If they have, the compensation the employee will achieve would then be increased by up to 25%.
Wow, okay. So could you put that into context for us?
Yes, so I can give you a pretty eye-opening example. There was recently one of the largest sexual discrimination awards against the City company, following an employee being subject to lewd comments, including, "I bet you like to be on top in bed," and being told to take a more submissive role. This saw the employee awarded £1.3 million in compensation for her claims. If that claim had reached the tribunal after October of this year, the tribunal would have increased that compensation by up to 25%, which would have seen the employer paying out a further £325,000 in compensation, which is a pretty hefty increase.
Yeah, that is a pretty hefty increase, isn't it? I mean, that really is indicative of how important it is for organisations to recognise their responsibility under this new duty. Is there anything else we need to know on this point?
Yes, so the Equality and Human Rights Commission will also have the power to take enforcement action against employers who don't do enough to prevent sexual harassment, which could include conducting their own investigations, entering into binding agreements with the employer to ensure that they address the issue, which has taken place previously with the likes of McDonald's, and possibly even regulatory action against businesses. Now, the idea behind such strict penalties for breaching the new duty is that every employer understands their responsibility to protect their employees from sexual harassment and makes it clear to all that sexual harassment in the workplace is unacceptable, no matter how big or small. It's also worth noting, as I touched on earlier, although the legislation itself doesn't include employers being liable for third-party harassment, the Equality and Human Rights Commission technical guidance does refer to employers taking steps to protect employees against third-party harassment. So this will be something they can take enforcement action against.
Wow, I mean, we're talking some serious sums and some quite understandably serious accountability. I mean, compensation, I believe, is already uncapped with these types of claims. So the sky could really be the limit moving forward if people don't act on this in the right way. So obviously, tribunal claims we've mentioned, they're your bread and butter. Jess, are you able to give us a few more examples of some recent case law, the types of issues the claims are related to and the compensation awarded to really put into context the new financial consequences?
Definitely. So in a recent case against Lidl, a teenage employee was subject to unwanted physical contact, including having her bottom slapped and her thighs and waist touched, along with inappropriate comments being made by her colleagues, such as their desire to have sex with her. When she sought to raise these concerns, she was told to take it as a compliment. She was successful in her claim for harassment on the grounds of sex, along with other claims, and was awarded £50,000, £22,000 of which was injury to feelings. If this claim had landed after October of this year, this award could have been uplifted to £62,500. In another case, a male chef successfully claimed sexual harassment after his male boss repeatedly made sexualized gestures and sang the Victoria Wood song Ballad of Barry and Frida at him, and put specific emphasis on the repeated word, "let's do it." Now, he was awarded £79,000 as compensation, which, if the uplift had been applied, could have seen his employer having to pay out £98,750 as compensation.
And if I could just interject here as well, just to give some context on the potential volume of cases you could be looking at. We looked at some stats from data we analysed across our client base, across various different sectors, and we actually found that 1 in 7 grievances raised were sexual harassment related, and this has been increasing year on year. So this is roughly 15%, and that's not factoring the fact that many don't even put in a grievance at all. So then the risk is absolutely huge. And more awareness of the new law may also see more employees coming forward as well.
Yes, no, I'm sure that's right, Hayley. I mean, thank you both for that. Really is eye-opening. So we've mentioned reasonable steps a few times already, and the legislation required organisations to take reasonable steps to prevent sexual harassment. Let's get into what that's going to mean in practice. Jess, do you want to get us started on that one?
Absolutely. So there's lots we can all be doing, but I've broken it down into 4 key areas. So that would be policies, thorough investigations, risk assessments, and training. So the first would be policies, to ensure you have alongside your anti-harassment policies a specific policy on sexual harassment that is shared with all employees, monitored and reviewed regularly to ensure that it's up to date. Within that policy, there should be a clear definition of sexual harassment, and it be unequivocal that such behaviour is unacceptable.
So just to interject here, I think that using some case examples like those you've just mentioned would help to illustrate actually what harassment can include and help really bring the policies to life, Jess?
Yeah, that's a really good idea. Anything that simplifies the message and makes it as clear as possible will really help. The policy should also contain an effective reporting procedure that's easy to understand for employees to use when raising complaints, such as an online reporting tool. It should also reassure employees that their concerns will be handled confidentially and that they'll be protected from retaliation for raising their concerns, to encourage people to come forward when they see behaviour which is unacceptable. Ensuring that employees know they will be protected after raising concerns is particularly important, as it's something that a tribunal will look harshly upon when reviewing reasonable steps taken by the employer, as seen in a recent case where the tribunal paid particular attention to the fact that an employee was subject to a string of sexual assaults after coming forward.
Wow, that is absolutely shocking. I mean, after they'd raised it, it's, yeah. Is there anything you'd like to add here, Hayley?
Yeah, thanks, Simon. I think it's important to mention that once you've reviewed or written your policy, a practical tip here would be to ensure that you have each employee sign and acknowledge that they have received, read, and most importantly, understood the policy, meaning that they know from the start what the policy prohibits and that they may face severe consequences for violating it. We'd also recommend that you periodically remind your employees of the policy and keep the importance of why we have that policy in place. And you must have your policy easily accessible to all current employees and new hires. And don't hide that you have these policies in place, promote them.
Yeah, that's a really important point, Hayley, because sometimes we only refer to policies when we need them, which means it's easy to forget your responsibilities in your day to day. I think regular reminders are absolutely vital.
Yeah, absolutely. And I would also like to point out, for when employees are reviewing their policies, as Jess mentioned earlier, whilst third parties are not explicitly mentioned in the legislation, they are referred to in the corresponding Equality and Human Rights Commission's technical guidance. So businesses will need to take appropriate steps to protect their employees from this type of abuse. One practical step that could be taken here would be putting up signs around the building, reminding everyone, including visiting customers and clients, of your harassment policy and how inappropriate behaviour won't be tolerated. Employers can still be responsible for harassment or discrimination if they just ignored complaints about harassment from third parties and that they don't take any action to mitigate this. Such complaints can also result in reputational damage if you are not seen to prioritise the protection of your employees.
Thanks, Hayley. So the next area we'll cover off is investigations. As part of having a clear reporting procedure, the second recommendation is for employers to ensure they are properly investigating complaints promptly and thoroughly and taking action where wrongdoing is identified. This is particularly important as the Lidl example that we discussed earlier shows that having an anti-harassment policy alone was not enough. Lidl were criticised for allowing a culture to become commonplace and not investigating this employee's concerns.
Yeah, it is absolutely imperative that all complaints are investigated appropriately, even if they didn't happen recently. As an employer, you should be advocating a zero tolerance approach to sexual harassment in the workplace. So think about the impact to your culture, morale, and employee confidence if you were informed of an issue and didn't look into it or take it more seriously.
It seems really simple that complaints should be taken seriously, but already we've discussed some pretty damning examples of how serious complaints have been brushed off. So I think it's really evident there needs to be a lot more accountability.
Exactly. And I'd really like to make the point here that it's important to consider that the allegations of sexual harassment can have a devastating impact on all those involved, whether or not those allegations are found to be upheld or not. So investigations must be discreet as possible, and it's important you provide support to both parties and consider referring them to other support services, including any employee assistance programs you may have if it's appropriate. We'd also advise that when being informed of an allegation, that a discussion is held with the parties involved as to what their needs are. So specifically, what would they like to do in terms of the workplace and that interim period immediately following the allegations being raised, to understand their views and requests of the outcome of the investigation. Employees should also consider and bear in mind the respect of both the complainant and the accused, whether or not either party needs to take time off work, as well as consideration as to whether the accused needs to be suspended. Remember, though, that there may be other options you can consider here. For example, whether they can be separated from one another by amending their working hours or location.
Yeah, the practical issues here are far reaching. So thinking about these now and really planning how to ensure that the right questions are asked at the right time, I think is key to improving the experience of all involved.
Yes, exactly. And it's also very important that the complainant is not made to feel punished or isolated from the workplace for raising a concern. The actions that are required will be based on the nature of the allegations and the relationship between the parties involved and the needs of the business, remembering that discretion and confidentiality must be maintained throughout.
Yeah, of course. I mean, what about an instance where a complainant may not want to be involved or even assist in the investigation?
That's a really good question. And in this scenario, it's still important to conduct some form of investigation and document the actions taken, if only to prevent any reoccurrence of further allegations being made or any further inappropriate conduct taking place. Any investigations you're undertaking are going to follow similar lines to any workplace investigation, but a few additional points to bear in mind when handling sexual harassment investigations include timescales. So as I pointed out earlier, this will be a very distressing time for all parties. So it's crucial that the facts are ascertained as soon as reasonably practical, and any recommendations or action required is taken at the earliest opportunity so that the parties involved can move forward. An appointment of an appropriate investigation manager is also an important consideration. Now, you may have to think about the agenda of the person if you feel that this would prevent the employee from being open about the issue. And you also need to be confident that they are able to be impartial and unlikely to be influenced by the people involved. There should not be any conflict of interest or pre-existing relationship with either party, and they should be equipped and ideally trained and experienced enough to be able to conduct an investigation of this nature. Ultimately, the investigation is a fact-finding exercise to find out the truth. So it's important that the investigating manager is able to keep an open mind, not apportion blame, and there needs to be someone who will be respectful to all parties. Now, my biggest tip when starting an investigation, especially one of this nature, would be to ensure that you have a plan in place at the start. So understand what the allegations are and therefore what needs to be investigated, what facts need to be established, what evidence needs to be collected, and who needs to be spoken to. Another consideration is where you conduct the interviews. For instance, can these be held somewhere more private or away from other employees? This could have a big impact on how the employee is feeling and whether they will feel comfortable enough to be able to be open during the investigation.
Yeah, I absolutely see that. I mean, there's so much to consider which could make or break the experience of someone who may already be going through what is a traumatic experience. And these are some of the things that we've included in a checklist we've shared to everybody to prepare. But I think it's important that we said earlier about having a plan before these things happen.
Yeah, absolutely. And the checklist will be a great resource as well, because there is so much to think about. Now, we do know that dealing with allegations of sexual harassment in the workplace are not easy and will involve difficult decisions being made, including whether to contact the police, whether to investigate when there's an unwilling complainant, how to deal with the parties whilst they work together, and how to balance the needs of those involved with the needs of the business as well. But please don't hesitate to get in touch if you do require any further support.
Thanks, Hayley. That's super. So next up is risk assessments. The third recommendation is for employers to assess and conduct targeted sexual harassment risk assessments to identify risk factors and what actions can be taken to minimise risks. For example, when people are working from home, employers and employees are able to contact each other electronically, meaning harassment from a colleague could be taking place at home once the employee leaves the office. A step to minimise the risk of this would be to ensure that your policy on IT and electronic communication includes appropriate warnings against harassment and encourages staff to report incidents even if these take place on personal devices.
I agree, and I do believe that it's the leadership and management teams that can absolutely set the tone for an organisation to drive those positive actions that impact everyone, no matter what the size of the business. Having a strong leadership commitment towards managing and controlling the risks of sexual harassment to eliminate or minimise the risk is key.
Absolutely. I couldn't agree more that as a business leader, I need to take responsibility for creating and advocating for a culture where our employees feel safe and absolutely able to raise concerns without fear of further issues.
Yeah. Now, we do understand that every organisation is unique and different factors will determine the most effective prevention and response framework for your organisation. And to assist in this process, you may want to consult with your employees and other key stakeholders. What I would recommend is that there is an assessment of key areas such as the working environment and the employee population. So looking at whether there are any particular groups being placed in certain environments like women, young people, or employees who may not be confident in making a complaint in English that could expose them to increased risk. There also needs to be a consideration as to what socialisation takes place outside of the working environment, including whether alcohol is present, as this may be a big influence on people and their behaviours. And then finally, review the management structure and reporting processes as well. Asking questions such as, do any employees have limited networks or not many ways of interacting with more than one manager? And do employees know the informal and formal reporting processes for sexual harassment? And as a general guideline, preventive actions should be people-centred, practical, adaptable, and designed to minimise harm to everyone.
Thanks, Hayley. And a huge part of all these recommendations comes down to training. So the final practical step I would recommend for all employers is to provide regular and in-depth sexual harassment training to all employees, not just managers, as that won't allow you to rely on the statutory defence if faced with a claim. Effective training is more than just ticking a box and saying, this is what the law says sexual harassment is, so don't do it. Obviously, ensuring employees understand the legal standard is important, but like we mentioned earlier, it's just as important to include situational examples of what workplace harassment looks like in order to bring the learning to life. This should include less obvious examples, as quite often this is where we see the issues arise. I think people immediately think of just physical actions when they think of sexual harassment, but that's very much not the case. As we saw in the earlier example, where singing the Victoria Wood song, Ballad of Barry and Frida, and repeating the line, let's do it, was upheld as sexual harassment. Clearly less blatant than perhaps physical touching someone inappropriately, but as this case shows, things such as this will meet the threshold for sexual harassment.
Yeah, I couldn't agree more. I think that practical examples are so important in this particular instance. I think it really helps avoid any confusion and to combat any attitudes like those you've referenced where complainants were told to be flattered by inappropriate attention. Yeah, I think practical examples are absolutely key.
Yeah, exactly. Training should also advise employees of what to do if they experience it. So linking back to your procedures and policy and how their complaint should be handled so that your managers understand how to address concerns sensitively and confidentially. Now, specific manager training on how to role model acceptable behaviour, spotting inappropriate behaviour and what to do if they receive a report of inappropriate conduct would also support employers to ensure that their zero tolerance policy for harassment is communicated from the top down. Another important point here is to explain within the wider training how employees can stay safe when raising concerns if they're going to call it out in the moment. For example, perhaps if there's been alcohol involved or they're alone with the individual, it could be safer for them not to raise it there and then in case it escalates the situation even further. We'd recommend providing guidance on how to raise these concerns afterwards and assure complainants that not saying something in the moment doesn't mean they can't report it later. Helpfully, recent case law has given us some further guidance on what the tribunal are looking for when considering if an employer has effective training in this area. So in this particular case, the defence that the employer had taken reasonable steps to prevent harassment failed where the training was not meaningful and had not been repeated. The tribunal were pretty scathing in its criticism. I believe the words stale, out of date and tick box were amongst some of the words used to describe the poor training that had been delivered in that case. So in light of this, as Hayley mentioned earlier, it would be a good idea for employers to keep a record of who has received the training so that they can ensure it's refreshed regularly with up-to-date content, and then evidence, if they need to, that they have taken those reasonable steps.
Yeah, absolutely. I think it's a bit like the policies, isn't it? The same with training. It needs to be relevant. We need to provide employees with absolutely the right tools and information, and I think that's essential. Obviously, at Empowering People Group with our Learning Nexus colleagues, we have a lot of digital learning experience. And I think ensuring training is really engaging, accessible, and really easy to digest is vital to get people emotionally engaged in such an important topic. What do you think, Hayley?
Yeah, I couldn't agree more. Engaging training has to be part of the toolkit. Employees having increased awareness and knowledge of what isn't acceptable in the workplace, and that there is a zero tolerance approach to sexual harassment can prevent further instances, because employees will feel more confident that they'll be listened to and taken seriously. And managers will also feel better prepared and more confident to handle such situations, ensuring that instances of inappropriate behaviour are addressed in the right way and in a timely manner. Effective training will also enable employees to understand that there are serious consequences to their actions and that they have accountability for their own behaviour. Managers will also have more awareness of how to ensure control measures are in place to protect their teams, and employees will have more awareness of what to look out for if they witness or are subjected to any inappropriate behaviour, and know how to report it, safe in the knowledge that it will be handled discreetly and fairly. This should all in all empower individuals to act appropriately to create a more respectful and safer environment. Now, a few final practical tips I can suggest here to raise the profile of this new legislation could include using a variety of media to present the information. For example, have posters and leaflets positioned around the workplace. Perhaps invest in an engaging video or micro-learning video to engage employees on the topic. You could also hold group discussions in team meetings or have huddles about sexual harassment. And you could even perhaps get employees to participate in quizzes or worksheets on the topic to help validate their understanding and knowledge, as well as highlighting the seriousness of the issue and your commitment to ensuring that sexual harassment is prevented in the workplace.
Wow, lots for everybody to be getting to grips with, and thank you both again for that. So much to get in place before the 26th of October. So we have actually had some questions in, not surprisingly, while we've been talking. So let me just have a quick look and we'll see if we can cover some before the end. So first off, this is actually a really interesting one. So the new legal duty obviously comes into force on the 26th of October, along with the potential compensation uplift. Will this mean it applies to issues of sexual harassment that took place prior to that date or claims that are made before that date? Jess, I think this feels like one for you.
Thanks, Simon. And that's certainly a great question. So this isn't specifically addressed in the legislation itself. However, our view is that the new duty, and more importantly, the financial consequences for non-compliance, will only apply to events which take place after the new duty is in force, as that's when employees are expected to comply with the duty. If it was to apply to events which took place in February this year, for example, but the claim landed after October, it would feel pretty disproportionate to hold the employer to a higher standard of the new legislation when this wasn't in force, or the expectation when the sexual harassment occurred. Obviously, all that said, from a cultural and proactivity point of view, we think showing that you've started to take proactive, reasonable steps, like we've discussed today, well in advance of the October date, will show that you're taking the obligations seriously and ultimately setting and confirming expectations amongst employees and colleagues about what is and isn't appropriate behaviour. So I hope that answers the question.
Yeah, I think it does, Jess. Great stuff. Thank you. So another very interesting one is, with the backlash that we've seen against movements like #MeToo, where victims faced ridicule and the term was misused, how can we prevent this from happening again and ensure that victims or whistleblowers don't feel fearful or singled out for coming forward?
That's a tough but really important question. And I think education and holding people accountable are key. And this is where we should be making it really clear in our policies that harassment includes trying to silence, ridicule or shame victims, and that they need to be assured that that they're not going to suffer any adverse consequences if they do speak up. And if we do see this happening, we need to deal with it immediately and fiercely, for want of a better word. Getting clear communications out quickly and briefing your line manager cohort on their responsibility for dealing with this sort of behaviour is vital to creating that safe, psychological safe space in which employees feel comfortable that they can come forward without fear or retribution. Also, the purpose of the legislation is prevention of sexual harassment, so by taking proactive steps, and we should be encouraging employees to partake in that sort of speak up, speak out ethos. And in the unfortunate event where sexual harassment has already taken place, then that we put actions in place to stop it from happening again. And we take the learnings, and which is vital in giving employees that confidence to really speak up and have faith that their employee is going to do everything that they possibly can to try and address the issue and prevent it from happening again.
Yeah, great response, Hayley. Thank you. So the third one here that I've got is, when dealing with a grievance related to sexual harassment, does the complainant need evidence to prove it happened or the accused to prove it didn't happen? Jess, I think from a legal perspective, this is one for you.
So the short answer to that question is that the complainant doesn't necessarily need corroborating evidence in order to report sexual harassment and for the employer to then have a duty to investigate their concerns. Given the nature of sexual harassment, often their account of what happened might be the only evidence available. So in that circumstance, provided the employer has made every effort to explore whether other evidence is available which could support them in investigating those concerns and reaching a fair outcome, it may be that the employer only has the complainant's account against the accuser's account to weigh up before reaching a decision. Any relevant evidence that is shared by either the accused or the complainant, including text messages, emails, or directions to speak to witnesses, will all be helpful to ensuring that an employer is able to carry out a thorough and balanced investigation. Both parties would therefore want to provide evidence they consider as relevant, as the employer will only be making a decision on the evidence available to them.
Yeah, that makes perfect sense, Jess, and thank you for that. So looking at time, I think that brings us to a close. Thanks so much, everyone, for your valuable insight on the incoming legislation. Hopefully everyone has been able to join today is confident on the steps they may still need to take in order to be in the best possible position come the 26th of October and beyond. Jess, Hayley, thank you both for your insight and fantastic practical guidance today. As we've touched on the reasonable steps organisations will need to take to comply with the new duty, they cover policy, process, documents and training. The Empowering People Group is all about simple solutions to people challenges. So we're expertly placed to help you ensure that you've got everything in place, whether that's manager training, e-learning for all employees, or drafting new policies. We have the expertise to help you be compliant and create respectful and inclusive cultures. If there's anything that you've heard today that you'd like our help with, please get in touch using the contact form available on your screen, and we'd be delighted to chat through the solutions we have to get you to where you need to be. You can also scan the QR code on screen to book a demo of our Preventing Sexual Harassment e-learning course, and anyone booking a demo from today's session will be able to secure an exclusive 10% discount on the course. As I mentioned at the beginning, we've also included a handful of free resources for you to download, including a document checklist so you can cross-check the actions you need to take to prepare for the possible changes needed, as well as a board summary note, which can be shared with your key stakeholders, board of directors, so that they have a note on the key headlines of this change and the wide-reaching financial consequences. So once again, thank you everyone for joining us today and sparing us your time. I hope you've got value from it. We look forward to seeing you all on another Empowering People Group webinar in the very near future. Thank you.